Good evening, ladies and gentlemen. We welcome you to this 155th webinar being conducted by Resurgent. This webinar is being established for discussing the personal insolvency under the IBC, which is something new, very new. Reason being, though it was enacted or notified in 2019, but due to various litigations, it was not operative. Now it is very much a part of the total strategy of particularly the public sector banks, but also the private sector lenders and NBFCs. They are looking at this opportunity of recovering their debts from the personal guarantors. Just to brief you about the code and the provisions relating to personal guarantee. The bankruptcy law has emerged purely as economic legislation. Personal bankruptcy is, however, if it is not primarily social, but it is a sort of social legislation. Unlike the Western countries, in India, the stigma of personal bankruptcy is not easy to wash off. And definitely there are some certain unpleasant implications of personal insolvency, which makes it a formidable deterrent to the erring individuals. Where the guarantees have been given but they've erred, then there is a problem. The contract of guarantee is dealt by the Contracts Act 1872, where the liability of the guarantor is coextensive with that of principal. It is very important to understand that the guarantee contract is coextensive. It does not require any action to be taken on the principal debtor before taking any action on the guarantor. And in this manner, Supreme Court has paved way to commence the personal insolvency against the personal guarantors, even if the insolvency or liquidation proceedings against the principal debtor have not been initiated. The rights of the guarantor flow from the contract law. Several personal guarantors have recently attempted to use the absence of appropriate corporate debtor insolvency proceedings to oppose proceedings against them. However, having said that, Honorable Supreme Court has clarified those issues and has paved way. The law provides a short timeline for completion of personal insolvency cases. It requires to be completed within 120 days from the date of admission of commencement of personal insolvency proceedings. There is no provision for admitting claims after 21 days from the public notice regarding initiation of personal notice, which is a bit onerous on the creditors. The creditor has to move to the court if they fail to file the claim. However, having said that, there is a lack of record of promoters' asset is a challenge, which we will be discussing during the course of today's discourse. And public information about the personals is very, very restrictive. If insolvency is possibility, lawyers frequently advise their clients, promoters who have provided personal guarantees, normally to transfer the assets to family members, close relatives. Having said that, there are provisions where it can be unearthed. Now, today's agenda is basically evolving this, because this is evolving legislation as far as IBC is concerned. What we will be discussing today, we will be discussing the benefits of the personal insolvency, various stage of personal insolvency, the challenges that are being faced by resolution professionals as well as the lenders in operating these cases, the effectiveness of personal insolvency proceedings, and the treatment of personal guarantors under any other law. What are the gray areas in invoking personal guarantees? And what is the way forward for an improved legislation or improved compliance? Now I come to share I will introduce my speakers. I have a panel of very, very learned speakers. I first introduce Mr. Sanjeev Pandey. He is former DGM of State Bank of India. Mr. Pandey headed the NCLT division of the Stress Asset Resolution Group, the SARG. He started his career as a PO, provisionary officer in State Bank, and had various positions over his 35 years journey with the bank. He has worked on multiple assignments into commercial borrowings, project finance, business development, stress asset management, restructuring and resolution, BIFR, CDR, and definitely under IBC. He carries an exposure to international banking as well as head of treasury at SBI Singapore from 2009 to 2014. Welcome, Pandey sir, on this webinar, and we look forward for your for the wisdom that you will share with us. Thank you very much, sir.
Thank you.
I now introduce Mr. Anil Kohli. He is a chartered accountant and he is a designated partner in ARCK Resolution Professionals. Anil Kohli Saab is an insolvency professional, a chartered accountant, and a lawyer by profession. He is having more than 27 years of experience in financial and legal sphere, with expertise in banking, having handled wealth management, financial portfolios of various clients. He has a very, very in-depth knowledge of the market scenarios, formulation of investment strategies, complemented with requisite infrastructure and well-knit team of professionals for successful consultant in the family business, investment in retail assets, and market management. Welcome, Anil Kohli Saab. We welcome you for this, and definitely our panelists, our audience, as well as me, I will be learning a lot from you today. Then we have Anil Kumar Saab, chartered accountant. He is an associate partner with RRR Insolvency Services Experts LLP, a seasoned finance professional with extensive experience of more than 29 years in leadership roles by holding management positions or as consultant to head finance and accounts function of reputed conglomerates engaged in varied manufacturing and service sectors, including telecom, FMCG, metal, jute, cement, etc. He has also had various good senior positions in NBFCs. His last assignment as employment was a senior VP with Sham Telecom Group and played a crucial role as Group CFO for more than 3.5 years. Anil Kusar, I welcome you for this webinar and we look forward for your interaction. With this, I will now like to start with my deliberations. As I told you, personal insolvency is a bit new, and we will deliberate or we will discuss various stages. What are the benefits, as I discussed in the agenda? We'll take up one by one, and I will be asking certain questions. I will be getting some certain clarifications from the panelists. I would request my audience to send questions on the inbox, or they can email it to me. We will share my email. My team will share the email on the inbox, chat box, so that you can share the questions and we will try to respond to them. Pandey Saab, I will come to you. First of all, sir, what are the benefits of this personal insolvency? How do you think they are beneficial for the creditors, for the corporate debtor, as well as for the economy as a whole? I would like to get some views from you, sir.
Thank you. Very good question, Mr. Gupta. So basically, if you look at from the banker's angle, lender's angle, so I am coming from a bank. So you see that bankers generally accept a guarantee along with some collateral while making a lending, while giving a loan. And so far, the enforcement of such guarantees were very far and few, because as we know that in DRTs, the process is very, very long. And by the time it leads to any decree, nothing is left in the asset, neither with the guarantor nor with the property also value goes down. So what has happened, like over a period, banks have been enforcing personal guarantors assets through SURFACE, but only in cases where the asset is available, some mortgage or some security is available, that could be enforced. We were not able to recover anything from the guarantor. So from the lender's point of view, this new law under the IBC regarding personal guarantors insolvency, so this has provided a new channel. Like we can go after the guarantor's assets under SURFACE or in the insolvency also. The insolvency law provides us to keep the asset outside the process. So that is also available. The provision is there. Other than that, if we enforce the guarantee, so we can go after the other assets of the guarantor which are not mortgaged or encumbered to the bank. So that is the major advantage to the bank under the guarantee. To the guarantors, I would say not many advantages. Only advantage that comes fundamentally from this law, not only to guarantor but any individual, is that he can have a fresh start after the process is over. So after he gets a discharge from the insolvency or through bankruptcy, there is some period after that, which is the cooling period. After that, he can do a fresh start. He can start a new business. He can take a fresh loan. So that is the advantage for an individual. So that is, I think, the two major advantages brought in by this law.
I would like to.
Thank you very much, sir. Anil sir, would you like to add something to it?
Yeah, I think Sanjeev ji has covered major area, but from the corporate banker lender side, there was a severe criticism by all that the businesses have been taken, corporate have been taken by running the CRP and liquidation. But the personal guarantors, usually who are promoters and directors of the corporate debtor, have been enjoying a king-size life. They have all the luxuries. Corporate debtors have become poorer, they have become insolvent, they have been liquidated. But the promoters were enjoying the life, which they otherwise did not deserve. So for this criticism also, it was necessary for the government to declare those individuals as insolvent and bankrupt also, to take away the other assets which they have taken away. That was the criticism. By this, now, this whatever assets they have in their own name or in the name of the family members, resolution professional or bankruptcy trustee is able to unearth, that is a different question. But at least there is a legal effort to declare him insolvent and bankrupt. And that is called a stigma in the society. That is a stigma in the society. Nobody would like to be declared as insolvent and bankrupt. That is one part. The second part, from the individual point, Sanjeev has rightly said, India is a country which is family-run business. Individuals are suffering. There is a genuine case of loss. The individuals have suffered losses, and they want to start their economic life afresh. There was no legal recourse, time-bound process run by. This process is run by resolution professional. Resolution professional is regulated by IBBI and IPA. It's a transparent, well laid down process as compared to the other processes which we had before. So these are the two things which are very important. I would like to add there. In terms of benefits, it's a well-regulated process.
So it will add to the financial discipline in the market.
Yeah, thank you, sir. Anil Kumar sir, I will just like to ask from you, so what are the various stages in this personal insolvency which are to be covered and which are to be seen by the RP or the various stakeholders like corporate debtor or the guarantors. Can you throw some light on that?
Sir, as we see in this corporate insolvency resolution process, there are two stages. One is CRP, other is liquidation. Similarly, in this in the is personal insolvency also, first there is a personal insolvency resolution process. The opportunity is given to the guarantor, to the individual to submit a repayment plan. That is a time-bound process. Within 120 days, the resolution professional has to submit the plan, and honorable NCLT or any adjudicating authority like whatever is applicable DRT has to approve the plan. If the resolution plan fails, the repayment plan fails, or the personal guarantor does not comply with the resolution repayment plan, then the bankruptcy trustee process has to start upon the application of the either by the creditor or by the individual debtor himself. So one stage is personal insolvency resolution process. Second stage is bankruptcy trustee. And in bankruptcy trustee also process, there are two stages. Within the beauty of the law is that within 180 days, whether the process is completed or not completed, that individual is given a discharge. That individual is given a discharge. The bankruptcy trustee may continue with the process because bankruptcy process is very complex, very difficult, very exhaustive as compared to personal insolvency resolution process. Because during bankruptcy trustee, he has to investigate the assets of the individual. He has to acquire the assets, occupy them, take them into a bankruptcy estate, and then sell them. Then he has to unearth the proof transaction also. During CRP, RP does not have any responsibility to unearth the proof transaction that we call preferential, undervalued, extortionate credit. But liquidator has, a bankruptcy trust has this responsibility. After the entire bankruptcy estate is disposed of, then the process gets completed. This is how the process is divided.
Thank you very much, sir. I think it was very, very enlightening in this regard, because now we will be starting this bankruptcy personal or personal insolvency against the personal guarantors. Anil Kohli sir, I'll come to you. I just request you to can you give some ideas about the major challenges that any resolution professional is facing during this implementation of personal insolvency, including the bankruptcy. I'm not sure if we have more cases of bankruptcy, but I would like to just have your experience or your views on the challenges, sir. Sir, you are mute. Can you unmute yourself?
So thank you, boss. Thank you very much, Gupta sir. So basically, bankruptcy, yeah, definitely right now, I don't think any process has started. We are in the initial stages of personal insolvency itself. Hardly 7-8 cases have been admitted till now. So that has begun. So the challenges, first of all, is this is a new kind process where we all have to, devise certain things like, we may start from maybe the format for public announcement. When one of my process was initiated, so there we could not find any format, for the public announcement. Exactly. So, so we have to first of all devise that format by ourselves. Now the question came, so which creditors should we invite? So do we invite only the creditors related to that CD for which he's a personal guarantor and for which this guarantee has been invoked? Or do we invite the creditors worldwide? Basically, world at large should be invited, that for any kind of guarantees given by him or maybe for any other debts owed by the guarantor, so need to be addressed here. Because, insolvency or declaration of bankruptcy of a person, we cannot basically be based on only one CD, only for the debts of one CD. Till the time we address all the debts, since all the assets are to be accounted for in this process, even if those are charged for that CD or maybe charged for some other facilities. So otherwise, if we take into account all the debts of the assets of the person and do not account for the entire debts owed to the world at large, so that will be an imperative. So we need to, first of all, so that's why I applied my mind, and I discussed with my advocate also. He was of the view, no, sir, only for the CD whom, for whom this guarantee has been invoked, we have to take care of, we have to ask for claims for that CD only. I said, no, that cannot be. So I gave the same logic. So we have to first of all discuss, and this happened even in CIRP liquidation. We have devised so many things. There was no concept of a process document. There is nothing called process document in the law. Now RFRP is there. So earlier there was no concept. So we did, first in the initial stages, we devised that process document by ourselves. The format was devised by us. Then even in liquidation, the process document and how to give sales certificate. Even there was no format for the sales certificate. So we had to rely on the SURFACE sales certificate. So these kinds of things in the beginning, we may need to find out the solutions for all these issues. Like I have told you, this was a major challenge. Which kind of debt should be invited? Which kind of creditors should be invited? So world at large. So then comes the lack of information. What happens is, basically for a company, you have an information for assets, charged assets, at least on the MCA. We have their balance sheet in the MCA, which is available on the public platform. Here we have to depend on entirely on the information to be provided by the guarantor himself, by the individual. So there may be, first of all, the challenges of his cooperation. Maybe that person cooperates or not cooperate. So getting that information from that person is a big challenge. Then, that correctness of that information. So what I did is, in my matter, since the entire management of affairs is to be prepared by the information we receive from the guarantor, what I did is, maybe later on this information comes out to be wrong, so I should bind him by some way. What I did is, I asked him for an affidavit. You give me an affidavit that the information you are providing is true and correct. So that way, at least binding him to some extent by CRPC, at least for perjury. So we can ask later on, take him. So then, getting a repayment plan, we have to convince him that, yeah, you should come forward and give a repayment plan, and you should settle your debts, then to make him, give a presentable repayment plan. It should not be like 200 crore debt and he's giving a plan for 2 crores, because he'll say, my assets are only worth that. And we cannot, in this process, one more drawback is we cannot investigate the affairs. So we have to rely on whatever he has given. Only in bankruptcy proceedings under section 149, we have the right to investigate the affairs. There is no right available with the resolution professional in the scenario of personal insolvency. So there, he may say that I have only this much of assets, so I'll be offering only such an amount to the creditors. So then you have to convince him, you have to make all the efforts to make the repayment plan presentable before the creditors. Then you have to even assist him in preparing the plan. So, and then convincing the creditors so that your matter is resolved. Basically, as was being discussed by my learned panelists, co-panelists earlier, the biggest benefit in this of personal insolvency, what I find is, that is, first of all, there is something which has begun, it should end, there is a person who has made default. If we keep on lingering the issue, and we keep on entangling into an endless litigation, like an OA remains pending in DRT, so the time of the courts, even the cost, its cost to the bankers, there was an estimate that there is a cost of 18% for carry forward of every NPA per year. So there it has to end. So personal insolvency, the biggest benefit is providing exit route, giving an end to the matter which of default, and so that now we can move forward. A person has been the entire issue has been addressed. Whatever best could be recovered, whatever best could be done has been done. So there is no need to now endlessly waste the time of the courts and all these things. So I feel that is the benefit, and the challenges I have already informed you. So maybe later on, from time to come, we will find out so many more things, and we may, then we'll address these challenges also.
अनिल सर, आप कुछ और बोलना चाहते थे? अनिल कुमार सर.
Kohli ji has rightly covered two major issues. I would like to add here the delays. The delay in, we say it is a time-bound process. Now, in case of personal insolvency resolution process, the appointment takes, first stage is appointment of the resolution professional.
Yes.
Then there is the admission. There are two stages. First is the appointment of resolution professional, then admission. The law provides the 14 days honorable NCLT or DRT to take before admission. But the two judgments which have come, the NCLT has decided that the notice has to be served to the corporate debtor and all the creditors. So now the honorable NCLT and DRT is also handicapped to admit in 14 days. When there is a notice to be served, it means there will be some response to the notice. There will be rejoinder. Thereafter, Delhi High Court has also decided that the corporate debtor should be provided the copy of the report. He has a right to object.
Yes.
He has a right to object. Now, practically, if you see, the admission itself is taking more than 8 months or 9 months. I have given my consent in 2 cases in more than 1.5 years. They are still not admitted. So the challenge is the maintaining timeline by the judiciary. That timeline is mandatory for the insolvency professional for doing all those things. That is one challenge.
I think there will be some reform which we will see in near future. I appreciate that your concern, but we hope to see some light in the day in near future, because yes, because the cases are more, and definitely there is a limitation to the judiciary.
The judiciary has to do justice.
Cases are piling up on day-on-day basis.
If the process is made in such a way that the individual debtor have a right to object, then certainly the admission will take time. The other issue is the fee. That I would like to point out for certain aspects about the fee. Now, there is a discussion paper on the proposed fixed scale of fee for insolvency professional to be appointed as IRP or RP of the corporate debtor. There is no such minimum scale of fee for getting appointed as RP. In case of bankruptcy trustee, like liquidation, there is a table which will be paid to the bankruptcy trustee. But in case of resolution professional who is appointed for the individual, the fee is a big challenge, because with due respect to our own professional, there is undercutting, and people are quoting very low amount of fees to get the assignments. That is one thing. The second thing is that who will bear the fee? The applicant, repayment plan. If there are no assets thereon, application, there are more than one creditors. The application is made by SBI. Later on, we come to know there are no assets with the individual debtor. Will the SBI bear the entire cost of the fee and the expenses?
I think, sir, in this case, going forward, when there will be some jurisprudence will share, and I think that will come into fore, because definitely these are some gray areas or challenges that we are facing. I fully appreciate, and sir, thank you very much for your inputs on that. Pandey sir, coming to you, see, at one point in time we are getting into the corporate insolvency, and as we discussed initially, there is a parallel action which can be taken, or even before taking any CIRP process, we can take action against the personal guarantors. Now, there is a possibility, sir, I'm taking a possibility out of it. My personal insolvency you have taken care of. Now in personal insolvency, when you started, you have taken because it is only gone to guarantors. It is not going to non-guarantors. This money will be going only to guarantors. Now what has happened in personal guarantee? If you have recovered a lot of amount as a guarantor, then to that extent your CRP, under CRP the amount will be lower, and definitely under CRP the person who's acquiring, because they will be taking the business as a valuation of the business enterprise, business valuation. So that money will be in other way will be paid to OCs or other creditors, which otherwise would have been paid to the guarantors or the secured financial creditors as per section 53C, 53 or C. Ultimately, he would have definitely decided to pay to financial creditors to get the more votes and all that. So, sir, in this case, does it not having a twice recovery of twice two actions against the same debt?
Oh, yeah. So, no, actually, if you look at the structure of a transaction when we give a loan, so these collateral and guarantees are treated as credit enhancements. So I cover my credit risk by taking additional securities. And as we all know that when a company goes into distress and then insolvency, immediately a considerable value of the asset is lost. I keep telling in my webinar that even the incidence of issuing a public announcement, that itself brings down the value of the CD by 10 to 20%, maybe sometimes 30%, because now the
Absolutely,
market knows that this company is under insolvency, so their credit is reduced. Nobody extend credit, nor banks, nor the market, and debtors generally avoid payment. So that's why, and the buyers also back off because they don't know what will happen to this company. That is the loss of value. So ultimately, as we have seen in last 5 years, the recovery through resolution under CARP, so average recovery comes around 40 to 45%. And if we exclude some larger transactions like SR Steel, Bhushan Steel, so average would come down to approximately 30%, 29-30%. So ultimately, the creditors are losing, and I'm talking about financial creditors here, because operational creditors in, I think, almost 99% cases have not recovered anything. So
exactly,
financial creditors themselves are losing 70% of the value in this enterprise. And as my friend Mr. Anil already said earlier, that in India what's happening is that the companies are going sick, not the promoters. So that is the vidambana, I can say, that is the problem in the market, that promoters, when he comes to the bank to take a loan, he comes on a scooter, and when he comes to give me tell me that I'm going to the court, you go to the court, he's coming in a Mercedes or a Bentley. So he is not sick, not only the company. So here comes the value of this personal guarantee. So to answer your question, it is not double jeopardy or double impact, because first of all, most of the assets of the guarantors are created from the CDs, income from the CD or diversion from the CD. That is one. So our challenge is to how to access those assets, first of all, or how to trace those assets, then have access to those assets, and then bring them under the law, under the resolution, and sell them and recover something. And law is very clear that once I recover from one guarantor, then immediately the claim against the another guarantor also goes down, not only the CD. So my claim from this guarantor will immediately reduce in respect to other guarantors. So all the time the claims will keep on revising as we get these settlements or resolution done. So one guarantor settled, the claim against other guarantor will reduce. The next guarantor settled, remaining guarantor reduced. Finally, all guarantors settled, then CD's claim will be reduced to that extent. So law is very clear. Bank cannot have double benefit of recovery. So that is
sir, I will just point out one very specific case. I have not named the case.
Yeah.
Where we are finding that the resolution plan is providing for 100% payment to the secured financial creditors. Okay. Now they are also the guarantee holders. The personal guarantees also has been given to only those financial creditors which are secured financial creditors. Now, had they started the personal guarantee insolvency against the personal guarantors, what will happen? Look from that perspective. Again, there is an advantage and disadvantage for some of the creditors. I'm just not discussing those advantages, but I'm just putting the things in different perspective. In this case, what happens that had they gone for the personal insolvency of that personal guarantor, they would have recovered, for example, maybe 10% or 20% of the debt, total debt.
Yeah.
Balance 90% they could have recovered from this, and that 10% or 20% would have gone to ultimately the operational creditors. Because normally, as a business, when I am acquiring a business under either acquisition or merger or IBC, ultimately what I am doing, I am assessing the value of the business as a going concern. No, definitely I will be paying as an acquirer, I will be paying that amount to the people, to the claimants. And definitely it will not be 100%, but to that extent, that 10% or 12%, whatever has been recovered from personal guarantor, theoretically it will go to the operational creditors.
To answer your question, there will be two situations. One is where the corporate debtor is settled before the recovery comes from guarantor. There, I think there is no issue. The bank will only recover the remaining amount, whatever haircut they have suffered during CRP or liquidation. Your question comes when the recovery from guarantors come upfront. If it comes upfront before the approval of resolution plan, of course, the claim will be reduced in respect of the financial creditor. Now, the plan is also approved and the recovery also comes. So, I think there it is, law is very clear. Bank has to deposit that money back to the resolution professional to be distributed among other creditors. So, we cannot have double. Only challenge will be that in case bank has suffered like haircut by way of interest or charges, like we may have recovered the outstanding amount, but there is always a haircut in case of interest. So that is also recoverable. So even that can be recovered from the guarantors. So if you say I have recovered my 100% outstanding, still I have not recovered the interest for last 3 years, that is recoverable from the guarantors.
Fine, sir. Thank you very much, sir. Now, Kolisa, a very small thing that I would like to understand. See, under the present law, we can admit the claims up to 21 days. Even under CRP, we are having 30 days for claims and practically 90 days. Extended period is 90 days. Claims can be admitted. In this case, sir, see, lack of information, lack of follow-up. See, sometimes I may be having a guarantee, but I'm not aware that some personal insolvency of the particular person has started. Now, will it not be very onerous that after 21 days my claim is not admitted? Then what will happen? That I will definitely approach NCLT, and again a burden NCLT. I'm again burdening with new set of applications for admission of my claim. So, how to solve this riddle? Sir, again, you are on mute. Can you unmute, sir?
Yeah, sorry, extremely sorry. So basically, yes, this is a very huge issue, wherein there are so many things which take us towards litigation. And definitely NCLTs are very much overburdened. I was just thinking, just before this conference, that why not, certain issues which are, which can be addressed by way of usage of IT or information technology, that can be introduced like IU, information utility. Now that is a nice concept. If the RP, he may get information from the IU, and on the basis of IU, even if that person has not submitted the claim, he has to, because IU information, we take it as an authenticated information. So why not, he take the RP, even in case of CRPs or personal insolvency, he takes the information from the IU and admits the claim by himself and informs the person, yes, we have found this claim, or maybe at least he should approach, the RP should approach, the creditors, which the information is available on the public domain, so that at least the people, who he knows, like, find the financial creditors, he can get the information from MCA for the company. And there, it's generally the document is there where guarantees are also mentioned, where all they are. Or he can get the information from the guarantor himself, that who all are your creditors. So he may also approach them so that at least, this thing may be taken care of, that there is no unnecessary litigation. So these are all informations which are available on the public domain, or he may get from the guarantors himself. And secondly, above all, if possible, the law should be like this, that definitely up till the approval at least of the plan by the COC, till that time claims should be acceptable, like it is in the matter of CARP. That should be there. Definitely, we must find out avenues to to avoid litigations, because these are actually, this is going to happen, and this will delay the process. Otherwise, the process can be carried out. Even the CRP, if these kinds of litigations are not there, we could have actually completed within the time allowed to us. Only thing which is taking us 90% of our time is litigation, which is delaying the processes. So these kinds of lacunas should be addressed.
Sir, in this stage, I will just like to share one of my views to you. Sir, in this case, there is a possibility like MCA, because now the law has come, particularly of personal insolvency. In view of this, can we suggest to government that we have some portal where wherever the guarantee is given by any individual, that should be posted or that should be registered with that, any guarantee that has been given. And the receiver should ensure that the guarantee is valid and it is available on the portal. And for that, it will have two advantages. One is for the insolvency professional, where he can take information from that and take out. Second is, it will also give a publicly available information, because these are the guarantees which have been given. Now, for example, if even for lenders, if you see, a lender doesn't know how many guarantees he has given, a person has given. He may have given a guarantee of 15,000 crores against the asset of 500 crores, where everybody is thinking that this is my security of 50,000 crores. 500 crores are I think this is high time that where a legislation or some regulation should come, then any personal guarantee should also be recorded or registered with some portal. This is my suggestion, sir.
I can come here. So we have made a suggestion from SBI side to IBBI that why not provide this responsibility to the information utility.
Yes.
So whenever a bank is sanctioning a loan or taking a guarantee, whether corporate or personal, so it should be recorded with information utility along with the loan. So I think that will be taken forward. So very soon it may come.
I would like to add here, sir. The ecosystem of information utility has certainly to be developed to incorporate the guarantees also. But there are two things. One is, during insolvency, personal insolvency, there is no classification called operational character and financial character. So there may be operational characters also.
But generally, operational character don't get a guarantee.
There may be operational characters also who also will like to submit their claim. So ecosystem has to get evolved where even suppliers of the services and goods to get registered, to register their claim there also. That is one part. And second part, as regard delay is concerned, see, even in the proposed amendment of the CRP, they are coming out with a timeline. We have to trade off between timeline and the full justice. If you want to give full justice, then the process becomes endless. We have to have some timeline. I will differ here that the time to be given to for the claimant to submit the claim till the repayment plan is approved, then repayment plan will never get approved. It will never get, because then it will become a dynamic repayment plan. Every time you get a new claim, you have to again amend the repayment plan. You have to go to the creditors for approval also. So that is that we have to end somewhere. We have to give we can give 21 days or 42 days, but we have to end there. In order to give justice to all the creditors, it cannot be ever ending.
Thank you very much, sir. I think it was a very, very interesting and very thought-provoking discussion that we are having. Coming to another point, sir, Kohli Saab, again, it is a related portion. because we discussed about the delays. Now, this personal insolvency we have to complete within 120 days. The bigger challenge is ki, see, there are litigations, there are problems. I will say in one of my case, my personal experience is in one case, the resolution plan was, because submission of resolution plan is not mandated at by what date you have to submit. You have to submit as an RP, you have to submit a report within a particular date of last date of claims received. Now, the issue that we are facing is ki, on the second last day, I will say that the repayment plan was received, or repayment plan was not received on the last date. How to prepare that report? Because I am, as an RP, I am mandated to submit the report to an honorable NCLT on that date, whatever the position is. I required some information, some days, some time to review that. Number one. Number two, similarly, there can be a lot of litigations. How to complete this within 120 days? Because nobody would like that these dates are extended, or the person should be taken to bankruptcy just because there was a litigation, or because litigation can be from various stakeholders.
So, as rightly you are saying, and we have already discussed that the matter is of litigation. Basically, why time is short is because of litigations, which was there in CRP as well as here. So what I feel is we need to first of all unburden the NCLTs. I have a proposal. I just thought, we can give a proposal that administrative kind of things, administrative kind of issues like confirmation of resolution professional, filing of progress report, even filing of report under section 106 about the holding of meeting, about 112 for receipt of plan, that report. All these kinds of reports can be given, this job can be given to IBBI, where there is no requirement of any adjudication, there where NCLT's intervention is not required. It's generally they will take it on record. They will say, fine, we have received a report, we take it on record. Confirmation as RP, this is not required to be given to NCLT. What jobs I think should be given to NCLT are like initiation of insolvency. That is definitely, admission is a process where adjudicatory mind is required to be applied. Then is non-cooperation of PG. Definitely without intervention of court, that cooperation we will not receive. Third is approval of a resolution plan. Yes, there is a requirement of application of mind by the adjudicating authority, and it will become enforceable. Then liquidation or bankruptcy. These four things I think must only go to an adjudicating authority. All other issues like replacement of RP, filing of reports, extension of time, even for extension of time, I will say, for that matter. And I to that extent, even if due to lack of time, some claim is rejected, that may also be considered by IBBA because no adjudication is required in this. So NCLTs need to be unburdened, first of all, so that litigations are resolved as fast as possible. Otherwise, this 120 days time definitely, because of this litigation, will be a problem. And then about the non-cooperation, as you have mentioned in your question, non-cooperation by the guarantor, that is also going to be definitely endless. In that situation, like, there should be a provision that you wait for the information for particular time, and if not received, then we go for straight away bankruptcy. And so if the time lapses, where bankruptcy should be initiated, and immediately bankruptcy proceeding, you take account of all the assets, take custody, control, and put it on sale. So in case of non-cooperation, we should not then stress for go to litigation, stress for a repayment plan. That means he is not in a mood to repay. So repayment plan cannot be enforced. Coming forward for settlement cannot be enforced on a person. If he is not willing, there is no issue. If we should not, in case of non-cooperation, I think we should not go to court even. We should not go. We should immediately, there should be a timeline that 30 days we give it to him, that if you give the information or submit a plan, fine, else bankruptcy initiates. So for non-cooperation in this matter, I don't think there is a requirement to go to NCLT, because it is about the repayment plan. It is about coming forward for settlement. You cannot force any person for settlement. So if he is not cooperating, let it be bankruptcy.
Absolutely, sir. Only thing is that this may, in some cases, become onerous on the individuals as well. Because if there are certain very, very genuine cases of non-submission of a repayment plan, and if it is directly going to bankruptcy, so that may become something which may not be fair to the people who are into this problem. But I think only those cases, and those cases should be seen and adjudicated on a prompt basis, can go to the NCLT, rather than having lot of hearings and lot of counter affidavits and affidavits. See, ultimately, as I will not refer, but normally we see ki, in first or second hearing, people can judge the the intent of the person who is coming. It is not that anything is required. And I'll tell you one very, very important case, though it was not directly for personal insolvency. It was relating to an affidavit of a related party, where the Honorable NCLT called the person, and within 2 minutes, he broke and said that, yes, we are a related party. Till such time when the lawyers were coming, I think everybody was fighting like anything. Nobody was relenting on anything. And when the honorable judge called the affidavit holder, okay, you come and present your thing. Within, I think, 2 minutes, he said, sir, we are related, and I'm ready to give the another affidavit to that. And even just said, do you know the implications of what you are saying? Well, sir, I know, understand, but I cannot change the facts. So this is the thing that I think sometimes people have to take that view, pragmatic view, rather than something which is, sir, fine. Thank you very much for a great deliberation. Lastly, I think I'll come to Anil Kumar Saab. Sir,
before you come, sir, I would like to add here something, sir.
Please, sir. Please, sir. Please.
See, legal recourse is a fundamental right of every citizen of the country. Now, how to, and we know our legal system, how strong and how weak and how efficient it is. Now, dividing this work of insolvency process between NCLT and IBBI, it will again open up a Pandora box. What are the jobs what are the actions which require adjudication, and what are the tasks which require IBBI involvement? Then IBBI also needs to be strengthened. IBBI also is a new baby. It's only 5 years old baby. IBBI also is not able to handle. There are complaints, there are issues which have been referred to IBBI, and they are pending with them also. So we have to strengthen the entire ecosystem for that.
I'll add something here.
It is not only mere bifurcation, and then see, you are rightly saying the associate, the definition of associate is so wide. In the wildest dream, you cannot complete the definition. So somebody will challenge that I'm not associate, or somebody will say he is associate.
The only thing I will add here is that this law is designed as a summary law.
Yes.
Okay. And it is designed in a way to put a minimum burden on the adjudicating authority. Like it is kind of a tick box kind of a thing. Like you have to admit a case. So 3 things the adjudicating authority has to check. If debt is there, limitation is there, and default is there. Simple. But the courts are taking 1 to 2 years to decide on these 3 things, which is having no application of mind. So I agree with Mr. Kohli that he is telling that we should deburden, but there is no application of mind as such. Even for approval of a resolution plan, there is no application of mind. Just section 30 bracket 2, you see 5 things to check, 5 or 6, just tick box and you approve. Because you don't have to apply the commercial mind, this is already applied to SCOs. But problem with our courts is that coming from a judicial background, from CRPC and CPC background, they try to process the case as per civil procedure code. They want affidavit every time. They want somebody to prove. So all these things were not provided in the law, but somehow it has taken a different course. And now most of the time the things are argued in the court, which is not provided in the law. Here, there is no provision of witness or proving anything. Everything is proved before the RP. RP gets the proof of default, proof of claims, everything. So you don't have to prove anything before the court. But still the court wants, no. You bring the RP and ultimately RP is not listening. Only advocate is allowed to speak in the court. So I think somewhere the judiciary has not appreciated or understood the basic concept or the fundamental processes behind the law. And that is why they are dragging, and then they are complaining that we are too overburdened. If it is a 3-minute job or 5-minute job to admit a CIRP or individual insolvency, then if you are taking 2 years, then you are yourself burdening yourself. You are accumulating cases without disposal. They'll keep on accumulating. So the disposal is very easy under the law. Only thing the adjudicating authority have to learn about their limitations, that where their power ends and where COC power starts or RP's power starts, or liquidator's power. Problem is that everybody is trying to encroach into each other's power. So I think if they learn that, everybody learns their limitation, the law is very clear. Thank you.
Sir, I think it was a very, very thought-provoking discussion, deliberation, discourse today. To summarize, I would request Anil Kumar Saab to give us what is the way forward, sir, in personal insolvency, how we can improve. I think a lot of things have already come. I would like your final views on this, and then we can close. We are already 4:57, sir.
I think we already have the past experience of CIRP corporate debtor of 5 years. Whatever, as Pandey was saying, it is not only admission. Various stakeholders are referring matter to NCLT or NCLAT or Supreme Court on small issues. So let us not reinvent all those issues which are settled and they are similar to personal insolvency. They can be taken as a basis. The learning which we have done from the corporate insolvency, that learning can be applied. And very rightly said, this is a summary law. Our courts, our NCLT and CLAD also we should be trained and educated so that they understand the significance of the timeliness and the significance of the issue which is raised. For a tiny issue, there is no need for several hearings or giving opportunity to everybody because they have a right, legal right. That is one thing, our learning. And as we are seeing discussion papers on various subjects coming, which is being discussed, and finally the amendments will come in the regulation and rules of the corporate insolvency. The same amended before we experience go to the court. The same thing can be applied to individual insolvency and bankruptcy trustee without getting into adjudicated by the NCLT or DRT. That experience can be applied. We have to trade off between time and justice. We have to trade off.
Sir, thank you very much. And I thank Anil Kohli Saab, Anil Kumar Saab and Sanjay Pandey sir for a great session, sir. I think, I don't know about others, but I have learned a lot of things from you today. And I hope that my audience has also got some information about the topic. And we'll continue to host such webinars for people like you, dear colleagues, whosoever have joined. I thank you for your patronage, and thank you, panelists. Sir. Thank you very much.
Thank you so much for giving this opportunity.
Thank you very much, sir. Thank you for giving your opportunity.
Thank you, colleague.
Thank you, Sanjeev sir. Thank you, sir.
Thank you,
Sanjeev ji.
Thank you, Sunil ji.